Hello, I'm Walter Shapiro, staff writer for the New Republic, and we're going to have a very fast-paced but fascinating discussion. Normally I would say my mother would be so pleased. She wanted me to go to law school, and finally I'm on a panel with such legal talent. But I won't digress because we don't have time. Directly to my right is Michael Pollack, who is a professor at the Cardozo School of Law at Yeshiva, and he's also the co-director of the Brennan Center for Constitutional Democracy. Next to him in the middle is my old colleague from the Brennan Center, Wendy Weiser, who is the Vice President for Democracy, the greatest expert on voting rights and other issues. And at the end, we have Andrew Weissmann, who is a professor of law at NYU. He was also the lead prosecutor for a fellow by the name of Robert Mueller from 2017 to 2019. And normally I would give a long introduction, but let me go right into it, which is we're now in a situation where the voters in Iowa do not seem to be unhappy with the idea of Donald Trump as a Republican nominee, which brings us to a certain 14th Amendment case that is heading towards the Supreme Court. Do any of you think that is anything other than a slam dunk that the court will just reject what Maine and Colorado did in terms of barring him from the ballot under the 14th Amendment? Anyone want to weigh in on this?
I think we're in violent agreement that we do not think that the court is going to affirm the Colorado Supreme Court, but I think we might also be in agreement that we don't think that the court, this is Michael's point, the court writ large, in other words, that the majority of the court will weigh in on the issue of that was found by the trial court in Colorado and the Secretary of State in Maine that Donald Trump engaged in insurrection. So I think it'll be left to the voters to essentially be implementing the 14th Amendment at the ballot box because they can decide they do not want an insurrectionist in the White House.
Do any of you have any idea of what excuse the court will use not to say that Trump is barred from the ballot?
Well, I'll start by talking about what excuses I think they will not use. And I think that those are actually more important. As Andrew mentioned, I do not think the court will say that Donald Trump did not engage in insurrection. I think that is critical. And I think it's critical as people talk about the outcome of the case that is clear, that it is not described as a vindication of the claim of insurrection, which is going to be actually tried in the court of the ballot box, but also in other courtrooms and other forms over the course of the year. I also think the court is not going to and should not accept an invitation that they overrule the Colorado Supreme Court's interpretation of Colorado election law. There is a little backdoor attempt to try to relitigate a case that the court threw out last term to invoke this independent state legislature theory and to override state constitutional law and other judicial review checks on state authority in elections, and that would be a bad outcome. I don't think it's going to happen, but that's also really important. And I think that there's about 20 or so other issues that the court could rule on. There are many issues where the case could, side doors, where the court could get out of the case.
Let me say one more Trump question, since it hovers over everything, including the crisis of the courts in America, which is, do any of you have a sense of will there be a verdict in any of the criminal trials for Trump before the election? One of the most encouraging things that keeps popping up in polls is even a significant number of Republicans say that in theory they would not vote for Trump if he were convicted of a crime.
So, yeah, I mean, it's a guess, and obviously there are ways that judges can do what Judge Cannon is doing now, which is to pocket veto the trial before the general election. So I don't think that one will go, and I don't think Georgia will go. But I do think, absent the Supreme Court doing something which I really don't think they will do. I don't think they will have 5 votes for it. I think that the DC January 6th case, which in my view is the most significant case, I think that case and I think the Manhattan case are going to go to trial before the general election. And I think both of those will have a verdict before the general election.
Which may be the most important fact to come out of this entire panel.
Well, it's not a fact.
Well, I mean, were it to happen, it would be a fact. Forgive me for arguing with lawyers. It's a futile endeavor. Staying newsy, the Supreme Court today had arguments in what is known as the Chevron case, which is basically a dispute brought on by right-wing groups to overturn the 1984 decision that basically gives large scope to federal regulatory agencies. And if the Chevron entirely was overturned, it would eviscerate much of the regulatory activity of the federal government. Could somebody explain where we are on this and how and what your outlook is on it?
Sure. I mean, in the interest of maybe calming folks a little bit, I think that's a little bit overstating the importance of Chevron,
Okay.
or the consequences of overruling it.
That's why my mother is so disappointed I didn't go to law school.
Chevron basically says that when a statute is ambiguous, federal courts are meant to defer to agency interpretations of that ambiguous text. And so that does, as Walter said, give agencies a lot more latitude to interpret and act based on their interpretation of vague delegations of authority from Congress, as most of them are, pretty capacious, pretty vague. But the reality is that in the last 5 years, even 10 years, most courts have sort of gotten the message from the Supreme Court that this doctrine is at least disfavored, not outright overruled. And the Supreme Court itself has not relied on Chevron for a number of years in deciding any of these cases. And so we're already sort of living in a world without Chevron. And so the court coming out and saying, okay, we're now overruling it, the likelihood that it would really change a whole lot of outcomes, I think, is low. What I do want to point out, though, or frame it as, is yet another aspect of the court's assault is probably too strong a word. The court's endeavor to shrink the role of administrative agencies, to shrink the footprint of regulation, to make it harder for presidents and agencies to engage in regulation. And that, it's easy to talk about regulation as a sort of anti-business thing, but regulation protects us from health hazards, from unsafe vehicles, unsafe products, unsafe financial products. So it is a significant part of our lives that is at stake in this broader project.
I just wanted to add another perspective about really how astonishing it is. Even if other courts have gotten the message from the Supreme Court, it has sent a message, and it is already dismantling really the way that the law has covered administrative agencies for more than 40 years. This is yet another way in which the court is radically rewriting constitutional law, the relations between the different branches of government, and a whole bunch of other aspects of our democracy. And it's very rapid and very sweeping. And I think this is something that should concern us a lot.
Let me come at another aspect of the Supreme Court. In the hierarchy of ethical behavior, sometimes some of the jurists maybe are not exactly role models for abstemious lifestyles, starting with Clarence Thomas. We have had 782 editorials, 4,693 op-eds deploring this, 812 speeches on the floor of the Congress by Democrats deploring this, and no discernible change. Do any of you think that anything will be done by the court to deal with the level of embarrassment that Thomas and to a lesser extent Alito cause?
No.
So, yeah, no, that's not going to happen. But I think that one thing that we're seeing and that this illustrates is, and I'm going to relate it to Donald Trump, is this idea that might makes right and that there's no accountability with respect to doing the right thing. That it's shocking enough with somebody who, as the president, would do things like, I'm not going to respond to congressional subpoenas and to oversight authority with no consequence. Obviously, that's just one example. But you're talking to three lawyers, so for us, seeing it in the Supreme Court is really dispiriting, to say the least, because if there's any place where might makes right, it should not exist and is antithetical to what this country is about, it should be at the Supreme Court. And so that kind of behavior being not controlled by the justices themselves in a responsible way or by Congress is, I think, a real sign of the times, which is basically an attitude of what are you going to do about it?
So I agree with what's been said, but I will add that the outcry has had an effect. I do think we don't want to understate actually the way in which the court has responded to it. First, the public opinion of the Supreme Court is at an all-time low. That is in significant part to all of this discussion of corruption and all of those 843 editorials that you're talking about and speeches. But the court itself has been feeling the pressure. We saw that when Justice Alito went to the opinion pages of the Wall Street Journal to try to rebut some ethics allegation about it. And we saw it when the court voluntarily did something that it had been saying it wasn't going to do for some time, which is adopting a weak and unenforceable ethics code, but an ethics code and putting it out. And in the introduction to the ethics code, it actually said, there's been some misconception in the public about whether or not we have an ethics code, and we want to clear that up. It was feeling the pressure of all of this, and I think that has an impact on its behavior, and I think it makes a difference, and I think it, ought to continue.
I also think, I think it's absolutely right. I think the court worries about its own reputation, its own perception. But I also think, setting aside that sort of parochial interest, right, the court is aware, we're all aware, that they don't have anything other than our trust in them or our faith in them, right? They are unelected, they are life tenured. They know, as every government actor knows, and as every person knows too, right, that all that they have is our trust in them, and they're an important part of our democratic system. That's why it's, I think, particularly dangerous when, as Wendy said, faith in the court is at an all-time low, when that faith is what is so essential to a third of the federal government, and we don't know how to fix it. They don't know how to fix it, right? I guess I should say there are some ways we could think of fix it, but they're not going to do those things, right? And so in the realm of in the zone of things that are plausible, I don't know what those are.
Well, Congress can certainly step in and do a whole lot to fix this, and I'll leave you to ask questions about that.
One of the aspects that has always concerned me is when Thomas was quoted as saying, I can't live on $400,000 a year. That the whole, and nobody can, it's a tough life out there. But basically, there was a period, and I can exaggerate it a little, probably up through the Reagan era, where people in Washington realized that you had a choice. You can pursue a life of influence and power, or you can pursue a life of money. And you would give up one for the other. Money people did not sit on the Supreme Court, and Supreme Court justices did not fly private planes around the world to every vacation destination you could think of. And one of the sad legacies, and I really actually think it dates back to Reagan, is the blurring of that trade-off. Because There are many things wrong with America, but the idea that you gave up something to have power and influence, I always thought was an admirable thing. Moving back to the court, let's assume Joe Biden, pray God, is reelected, and you have a Democratic Congress, even though probably with very tight margins. Is there anything that can be done to reform the Supreme Court other than waiting for the normal demographics of the 6 conservatives?
So I'll start, and there are a number of proposals that are currently pending in the Congress. There's a lot of ferment and discussion around this. The one that I'll elevate first is term limits with regular appointments for Supreme Court justices. This is wildly popular across all political persuasions. This is how every other democracy treats its highest court. This is how 49 of our 50 states work. It is common sense. Americans understand that no one should have public power for that long. And it is something that has actually, Chief Justice Roberts, before he was on the court, was a proponent of it. Senator Ted Cruz was a proponent of it. This is something that has a long pedigree and support, and it can be done by statute, and that is key. It is something that is consistent with our constitutional system, something that Congress can do by statute. And can go a long way towards restoring faith in the system and to depoliticizing the Supreme Court selection process, especially when coupled with selection reform, which might require some more constitutional change.
Speaking of election reform, we've all been talking totally about the Supreme Court, but so many of the decisions that affect democracy and the 2024 elections will come from lower courts or from state courts. What do you worry about the most, and is there any optimism about how that this will be, in some ways, in terms of voter participation, a better election than 2020 or 2016?
Well, that's a very big question. So there's a lot of things to worry about in this election, and there are a lot of moving pieces, and there are a lot of efforts to suppress votes, subvert election outcomes, and there's a lot of strains on our election system across the board. And since this panel is about the courts, and so I'll just focus on it, the courts are seeing a couple of things that I think are threatening to the election. We're seeing a very big surge of litigation from people that are trying to use the courts to restrict access to voting. That was a new innovation in the 2020 election that the Trump campaign and allies brought to the system, and now we're seeing it fairly routinized as a way of trying to roll back voting access with affirmative litigation. That's going through the courts. Another thing that we're seeing is actually emboldened by the Supreme Court's rollback of voting rights and other democratic rights. We're seeing lower courts issuing increasingly radical decisions rolling back core rights and voting rights in particular. The Voting Rights Act has been the subject of a lot of very loopy and dangerous decisions that are really cutting it back. There is a crazy decision that came out of the Eighth Circuit Court of Appeals actually saying that private voters and groups representing voters don't have the right to enforce the Voting Rights Act. There's no private right of action, and so the 50 odd years of enforcement of the Voting Rights Act didn't exist. That was all wrong. Only the Department of Justice can do that. That is just one of many of those kinds of things that are going through the lower courts, and I think there's a lot of risk to future further damage to voting rights. I'll just add, the courts are still going to be important in thwarting election sabotage efforts. And we did see in 2022 a lot of courts stepped up when people were trying to deny certification or take other really radical steps to subvert election outcomes. Courts did step up. 2020, 60 odd courts also rejected litigation brought by Trump campaign and allies to try to overturn the results. So the courts are going to definitely be a very fraught playing field heading into this election.
Just a plug for the branch of government that actually has stood up, I think, fairly well, particularly if you look at the level below the Supreme Court. And to quote a judge from the D.C. trial court, the courtroom is still a place where facts and law matter. And particularly because between now and the general election, there is going to be a frontal attack on judges and the judicial process. It's going to be very important for people to sort of realize how well they have done, by and large, with minor exceptions, in adhering to their oaths of office. And I think there'll be tons of litigation. There's huge issues that Wendy has talked about, but I think in terms of, the sort of repetition of claims of that the election was stolen, at the end of the day, there are hearings, evidence is needed, judges are used to looking at the evidence and abiding by that, and these are judges who were appointed by the wide spectrum of presidents, and so I think they've done really well, and I think there's going to be a need for people in the country to understand that and to support the judiciary. I mean, we're seeing it today with respect to Judge Kaplan, who's presiding over the second of the E. Jean Carroll cases, and the former president, directly criticizing him for, doing his job.
And I think it's important, we were talking about the Supreme Court and the loss of public confidence, but I do think Andrew's right. It's important to not lose faith in the courts writ large and to understand that by and large, obviously with exceptions, but by and large, they are doing their jobs and they are demanding evidence and holding claimants to a standard of facts, say nothing of law, but of facts. And so I think as the American public, it's important to have the courts back when the court is trying to have democracies back.
One of the things in the Mitt Romney book came out that he talked about how a lot of Republican senators know better but are afraid of retaliation if they go against Trump. What we have seen with a lot of judges, court officials, is overt retaliation, whether bomb threats, what I guess the new word is swatting, where you send a SWAT team to someone's house on a slow Wednesday. And what I'm wondering is, what can be done beyond what law enforcement is doing now? And how much should we worry about a world in which judges and court officials are intimidated by threats of mob violence?
You have a lot of
So I'm going to be really quick, but I mean, obviously the investigation and prosecution is important, and as serious as a problem as it is with respect to judges and prosecutors and journalists. I'm particularly concerned about what is going to happen with respect to witnesses and jurors. Those are people where it could have an effect, and it reminds me of when I was a young prosecutor doing organized crime cases, and there were all sorts of steps we had, including the witness protection program. But the idea that we're thinking about that with respect to the former president of the United States is a sign of the world we're in. One example is to, again, refer back to Judge Kaplan. In a civil defamation case, there is a fully anonymous and partially sequestered jury because of the concern about the safety of the jurors. The jurors go by number, and they were instructed to not use their names even with each other because of and that is an extraordinary step even in a criminal case. But that is the kind of measure that I think you're going to see, whether it's the Manhattan District Attorney's criminal case against Donald Trump or the Jack Smith case before Judge Chutkan. You're going to see those kinds of steps, I think, put in place. For witnesses, it'll be a lot more difficult.
And I wanted to also zoom out a little bit and look at the broader climate of political violence that's being stoked here, and that is impacting judges, and we're seeing all of those threats and attacks and swatting on judges. And just a couple of years ago, the U.S. Marshal Service did a a study of just attacks on judges and found it increased and prosecutors almost fivefold from 2015 to 2021, and I assume that now it's only going up. This is part of a broader climate, and we at the Brennan Center have been tracking this, especially as it relates to election officials, so another group that has been suddenly found itself in the crosshairs of a election denier, movement that is increasingly threatening and harassing them. And they didn't have the protections that judges had. And I do think we found that the protections that judges had need to be bolstered. They are not enough. They're getting through. There was a really grisly murder of a judge's family member just in another, not related to these cases, a couple of years ago, but it's been, but even election officials didn't even have those basic protections against their personally identifiable information, like legal protections against harassment, physical protections for themselves or their offices that judges had. And so we are seeing this really across the board. And we know some of the measures that need to be taken, but with the advent of the internet and with the scale and scope of this movement, it's increasingly difficult to, we need to be investing a lot more resources and effort into this, into the safety of our public servants.
No, it's something I worry about, but while there's been a little hope in terms of talking about how the courts stood up to Trump and election denials, amid this moderately depressing discussion, let me end by just asking, is there anything else that any of you are really worried about that deserves more attention than it's gotten?
Yes, but
All we do is worry. No, I think something Wendy said is worth just focusing on, which is that there is a distinct possibility that the Supreme Court will be viewed as ruling in favor of Trump in the disqualification litigation. And I think it's going to be really important for people to understand that this is an issue that, there are lots of interesting, difficult issues on both sides. It is important for the Supreme Court to resolve it, and that's it. It's not a vindication of one side or the other. It's certainly not going to vindicate sort of what his conduct
Not
was.
even Bush versus Gore?
no.
Right, exactly. And so I just think that is the downside of the litigation having been brought, is that risk. And it's really important for people to think about the world where we could easily be in. Maybe we won't be, but I think there's a good chance after the court hears us on February 8th that we would be in that position. And it's really important for people to understand the framing of that, because certainly Donald Trump, as is right, will be saying this is a vindication, but I don't think that is the correct way to view it.
I think it's really important for journalists, some of you might be in the room, to frame these outcomes appropriately for the American public, right? That, headlines matter. I think, you see this a lot on the platform formerly known as Twitter, where, publications are taken to task for the way that a headline is crafted that might obscure a little bit some of what actually happened, to sort of tamp it down, or I think Andrew's right, to frame it in a way that obscures too much of the complexity, right? And it just sells it as Trump won the case. I think it's really critical that communication, the court does not do that communication. That's on journalists and it's on us. And I think it's really critical to be extremely clear about what happens, even when it's highly technical, right? But to say, this is what happened, this is what was decided, and this is what wasn't decided.
I'll add, we've been talking.
You get the last word, Wendy.
All right, thank you. I'll try to make it a good one. We've been talking both about the courts as safeguards or necessary backstop safeguards and enforcers of the law, but also the Supreme Court as a source of a lot of the challenges and problems that we're facing today, and wanted to underscore that a lot of the democracy protections and voting rights and rule of law protections that existed have been systematically dismantled by this court over the last decade and a half. But I will say, a lot of what's been done can actually be undone and fixed by Congress and by legislation. And I sort of want to end not on the depressing note, but on the, at some point, there will be a Congress, and it could be a point very soon, that can pass these reforms to the Supreme Court, put in place term limits, ethics reforms, whatever other necessary reforms are needed, and then can actually put in place systematic democracy reform, voting rights legislation, stuff that came just this close to passing before. And so we could really turn this all around if we make this the center of our political battle right now.
Listen, thank you, Wendy, for leaving us singing the title tune. You don't want people leaving the theater too depressed. Thank you, Andrew. Thank you, Michael.